Rylands v. Fletcher, the case that changed tort law. Imagine this. You build a beautiful reservoir to store water for your factory. One day disaster strikes, the water escapes and floods a nearby coal mine. Who's responsible? You didn't intend for this to happen. Should you still pay for the damage? This was exactly what happened in one of the most famous legal cases ever, Rylands v. Fletcher, 1868. And today, we're breaking it all down in a way you'll never forget. Let's take a trip back to 1860s England. John Rylands, a wealthy mill owner, decided to build a massive reservoir on his land to store water for his textile factory. But here's where things get interesting. Unknown to Rylands, deep underground, there were old abandoned mine shafts connected to a neighboring coal mine owned by Thomas Fletcher. When Rylands' reservoir was filled, boom! Water rushed into the shafts and flooded Fletcher's mine. Total disaster! Fletcher was furious and sued Rylands, claiming that his actions had caused the destruction of his coal mine. But here's the twist. Rylands wasn't negligent. He didn't know about the hidden shafts, so should he still be held responsible? The case went all the way to the House of Lords, and in 1868, they made a groundbreaking decision. If a person brings something onto their land that is likely to cause mischief if it escapes, they must keep it at their own risk. If it escapes and causes damage, they are liable, even if they were not negligent. This became known as the rule in Rylands v. Fletcher, which introduced a brand new legal concept, strict liability. This means that if you engage in dangerous activities, you're responsible for any damage, no excuses. Rylands builds a reservoir. But wait, this rule isn't applied to everything. There are 4 key conditions you must meet for Rylands v. Fletcher to apply. 1 dangerous thing, you must bring something onto your land that can cause harm, like water, explosives, chemicals. 2, non-natural use of land. It must be something unusual or risky, a reservoir, not a garden. 3, escape. It must actually escape your land. Foreseeable damage. The escape must cause foreseeable harm to others. Of course, not everything is black and white in law. There are some exceptions where you won't be held strictly liable. 1, act of God if a natural disaster like an earthquake caused the escape. 2, third-party interference, if someone else messed with your property and caused the damage. 3, plaintiff's consent, if the victim agreed to the risk. 4, statutory authority, if the government authorized the activity. So why should you care about a 150-year-old case? Well, this rule still applies today in cases like industrial disasters, chemical leaks, and environmental damage. In India, this rule was even expanded in the M.C. Medhavy Union of India 1987 case after the Bhopal gas tragedy, where the Supreme Court introduced an even stricter version, absolute liability, with no exceptions. So to sum it up, if you bring something dangerous onto your land, you better keep it in check, otherwise you're paying up. Rylands v. Fletcher is a legal game changer, and it still impacts environmental laws, industrial policies, and consumer safety today. Now let me ask you, do you think strict liability is fair? Should people be held responsible even if they're not negligent? Drop your thoughts in the comments. And don't forget to like, share, and subscribe for more legal deep dives. See you in the next one.